Hello, everyone. My name is Gregory Moloch, and our group did a congressional briefing, or we will be doing next week, a congressional briefing on Section 2 of the 14th Amendment. Before I kind of get into what I did specifically, I just want to say thank you, Professor Ifill. When I signed up for this class, I didn't know what to expect originally, but the fact that you have given us a means to kind of have a voice in oftentimes in spaces where we feel as though our voices can't be heard, and I just wanted to say thank you. So in terms of the 14th Amendment, I primarily worked on a brief overview of the section itself, or not the section itself, but the entirety of the 14th Amendment. I could say, like, we can go line by line, text by text, and look at the 14th Amendment with the swag bag that y'all had, but I don't think it does justice to what the 14th Amendment is. It was a means of serving as essentially addressing a series of nuanced issues that were created by the institution of slavery and perpetuated by the Civil War. Essentially, what the 14th Amendment did was served as a way to kind of protect individuals from the atrocities that were occurring at that time. It also overturned case law. We don't realize today, but back then, there was a time and place in which the laws did not consider people citizens regardless of their status. Additionally, it served as a means of essentially insulating the country from traitors, and oftentimes we didn't expect Section 30, for example, to be brought up, yet here we are today. But lastly, it also provided a means of Congress to resolve these issues. And I would like to turn it over to Jake and Maya to cover history.
Good morning. My name is Maya Buchanan. I echo Greg's sentiments. Thank you, Professor Ifill, for the opportunity. Thank you for your wisdom and your guidance through the semester. Jake and I are presenting on the historical context of Section 2. Jake focused on the conditions in the South after the Civil War, things like violence and massacres against Black Americans. I focused on the 1860 census, which showed that in several Southern states, newly emancipated and free Black people equal to or outnumbered white populations. And because representation is based on population, that meant that Southern states would gain political power by counting freedmen. So Section 2 was created in response to a concern to impose a consequence of states who counted freedmen for representation while denying them the right to vote. And Spencer, I'm turning it over to Spencer.
All right, hello everyone. Thank you all so much for being here. My name is Spencer Jones, and also
Hi, everyone. I'm Emily Daniels. Thank you for joining us.
yes, and we are so excited to present to you all about what the sort of practical impacts of Section 2, applying Section 2 of the 14th Amendment to today's sort of voting rights jurisprudence. We're excited to present to you all today and give you a brief overview of that. So as Maya stated before, Section 2's reduction clause says, and I'll streamline just a bit, but when the right to vote at any election for the choice of electors is abridged in any way, that the basis of representation therein shall be reduced in that proportion. So with that, we have created and are creating a hypothetical case study that is meant to show what meaningful enforcement of Section 2 of the 14th Amendment could look like in practice today. And as we know, for generations, courts have primarily addressed voting discrimination through individual right remedies under the Voting Rights Act and under the Equal Protection Clause, invalidating discriminatory laws, enjoining lawful practices, and so on and so forth. And what we want to make clear is that all of these remain critically important. But our work asks, with the increasing levels of voter discrimination as we see, what further ways are there to punish and deter jurisdictions from committing voter discrimination? That is where Section 2's reduction clause becomes especially significant. At a broad level, because it's still being formed, we are creating a mathematical framework, surprisingly though, since we're in law school, that does something relatively straightforward but constitutionally significant. It measures the proportion of eligible voters whose right to vote has been denied or abridged, and then applies that proportion to the state's representation in Congress. In other words, after a court has found a finding of some sort of voter abridgment on a population, the equation we are proposing translates a finding of voter discrimination into a proportional reduction of political power in Congress. And we believe that this revival of Section 2 demonstrates that voter discrimination should carry structural consequences, particularly with the concerted efforts of voter discrimination that we're seeing by this current administration. And we believe that if a state benefits from representation that is premised on the full inclusion of its population, but then unlawfully restricts that population's access to the ballot, Section 2 provides the constitutional mechanism to reduce that benefit. Thank you so much.
Hi, everyone. My name is Summer Ford, and I stand alongside
Arolua Adewale.
We cannot be the only ones who don't say thank you to Professor Ifill. It has been an honor to be under your brilliance this semester, so thank you. Ari and I had an opportunity to look at a couple of challenges and considerations that come up when we discuss restoring Section 2 as a voter protection tool. The first one is that Section 2, or what's raised, is that Section 2 facially discriminates on the basis of sex. And when people raise that argument, they're relying on language that says male inhabitants, and then a couple of times it says male citizens. And if we're to follow through with that argument, it would suggest that a state can disenfranchise its women voters without Section 2 consequences, which would render Section 2 a rather ineffective tool in protecting the voter rights of a significant portion of the voting population. The very natural response to that is that the 19th Amendment repeals that language, the gendered language of Section 2, in the same way that the 26th Amendment, repeals the language that we see in Section 2 that says 21 years of age, because we know the 26th Amendment lowers it to 18. In the same way that the 13th and 14th Amendments repeal the language of the Three-Fifths Compromise. So it's not a new dynamic that we're seeing, and that's the response to that challenge.
Okay, so now we're going on to, is Section 2 workable? So some core considerations for policymakers and advocates are representation, local leadership, and historical context. So for representation, does the proposed enforcement approach preserve or reduce the number of districts where Black voters can elect preferred candidates? Historical context. Are longstanding patterns of discrimination being fully considered when evaluating voting challenges? And for decision makers, are Black elected officials and community leaders effectively consulted in this process? And then lastly, it has obviously been a pleasure to work with Professor Ifill. All of us have been working really hard for months, and we've been researching, and we're presenting our findings next week, so please wish us luck. Professor Ifill has a standard of excellence, and we really hope that we rise to that. When I was a 1L, I worked for the LDF over the summer, and President Nelson actually told me that I must take a class with Professor Ifill, so I am very happy that I listened, and I'm lucky to have gotten in. So thank you, Professor Ifill, again. I think she's in the back, but thank you. We appreciate you a lot, and thank you, everyone, for listening.
Hello, everyone. Long time no see. And I also honestly would be remiss if I didn't just briefly talk about the inspiration that Professor Ifill has been, because obviously you turn on the news every day, really every hour at this point, and you wonder, where are we heading as a nation? Where is democracy heading? But being in this course where we quite literally reimagine democracy, it gives me hope, right? In the face of all the atrocities that we're seeing in our government, it gives me hope to know that we are among this community of like-minded individuals that still have this commitment to democracy. So Professor Ifill, again, just want to say so grateful to you and so grateful for the inspiration that you have been to all of us and to everyone in this room, for sure. And to move along, again, my name is Spencer Jones. I am a third-year law student here, and of course, I am in Professor Ifill's 14th Amendment seminar course, and our next panel is entitled The 14th Amendment and the Future of Voting Rights. And this panel will explore the evolving relationship between constitutional law and access to the ballot in a moment of significant democratic challenge. This discussion will examine the role of the courts, Congress, and advocates in shaping the future of voting rights, as well as the ongoing impact of the 14th Amendment on these efforts. We are honored today to be joined by Ms. Janai Nelson, President and Director-Counsel of the Legal Defense Fund, as well as, of course. We are also honored to be joined by Mr. Wilfred Codrington III, Professor of Law at Cardozo School of Law. Of course, we are also honored to be joined by the Honorable Congressman Jamie Raskin, Ranking Member of the House Judiciary Committee. And this panel will be moderated by the incomparable Sherrilyn Ifill. Please welcome them to the stage.
When you have a student who knows how to vamp while his professor goes to the bathroom, this is the kind of students we have here. Well, thank you all so much. I am so excited about this panel. Did the chair just fall apart?
No, it didn't. We're good. We're all good.
I don't want it charged to the center. I don't want the repairs. I can't think of a better panel to talk about this subject that is such a serious one, and that I wish we were having in a more positive context. But I think it's important that we wrestle with this, especially after the last panel on birthright citizenship and talking about the Supreme Court more generally. I'm thrilled to be joined by these three panelists who each are so steeped in issues of voting rights, who understand what is happening not only with the Supreme Court, but with the 14th Amendment and voting rights, and who can help us kind of figure out where we are and also do the work, as in every panel for this session, of where we need to go, of what on the other side of this can we do to ensure the protection of voting rights particularly for marginalized Black, brown citizens in this country. I am going to have to begin. Normally, I would begin with the Congressman, but we have with us Janai Nelson, who not only is the President and Director-Counsel of the NAACP Legal Defense Fund and my beloved and dear friend, but she's the person who argued the Louisiana versus Calais case in the Supreme Court this term. And as a reminder, this case is not only about the racial gerrymander that happened in Louisiana, which had gone to the Supreme Court, and it was the year after the Supreme Court's decision in Allen versus Milligan, the Alabama racial gerrymandering case. But then last summer, the Supreme Court decided that they had a question that they wanted to have answered. And I alluded to this in our previous panel. This is a question that came from the Supreme Court, but that was not litigated below. I think it was raised maybe in a brief by one of the parties. It's really not raised at all by the parties. This is what the Supreme Court decided they wanted to hear. They wanted the parties to brief and argue the question of whether you can use race in creating a remedy for a racial gerrymander. That guffaw from the outside, that fit perfectly. Essentially, if I'm wrong, you can tell me. The question is, if you try to fix a racial gerrymander, you try to fix a map that was created to diminish Black power, whether you, in fact, are the racist. Are you the person violating the Equal Protection Clause by attempting to fix a map that has been demonstrated to be a racial gerrymander? And so then the question, even more broadly is, can you actually remedy racism through the 14th Amendment? Are you violating the 14th Amendment if you try to remedy racism? And the setup for this question and discussion, as irrational as it sounds, but we just had a conversation about the irrationality of the birthright citizenship case. The setup, of course, is the Supreme Court's decision in SSFA versus Harvard the affirmative action case, or the case in which the Supreme Court struck down race-conscious admissions in colleges and universities, or at least in 2 colleges and universities, and insisted on the principle of colorblindness. Now, as I said last night, the word colorblindness does not appear in the Constitution. Let me say it again. The word colorblindness does not appear in the Constitution. Not only has it been taken up as the mantra of this court, it has been embraced as the moral high ground, right? That to say you're against colorblindness is to suggest that you are racist. But as I said last night at our reception, the project of drafting and ratifying the 13th, 14th, and 15th Amendments were the most race-conscious constitutional exercise that has ever been done in this country. It was utterly race-conscious, completely race-conscious. There was no colorblindness. They were setting out to address a particular problem, which was white supremacist ideology and practice in the South. But this idea of colorblindness has now become enshrined, and when they announce that it must be colorblind and that our Constitution is colorblind, they cite the great dissenter, as he was referred to in the birthright citizenship argument, Justice John Marshall Harlan, who dissented from the decision in Plessy versus Ferguson. And in dissenting from that decision, he said, our Constitution is colorblind. The irony is, in the very next paragraph, that same John Marshall Harlan says, but there is a race of people so different from our own that it would be preposterous to imagine that they could ride on the same rail cars as nice white ladies, but black people couldn't. So he wasn't racist against black people, but he was racist against the Chinese. And he said, I speak, of course, about the Chinese, a race of people so different from our own that we can discriminate against them. This is what he says literally the next paragraph after saying our Constitution is colorblind. And so now we have a Supreme Court that enshrines this principle that they believe takes the moral high ground, and they are unapologetic about citing this dissenting opinion in which the author of it reveals his own racism right after he says our Constitution. This is how crazy it's gotten. But using that concept allows them to set up the kind of question that they demanded that Janai Nelson answer in Louisiana versus Calais. And so I want to begin with her. We're still waiting for a decision from the court. And so, she's going to talk in a measured fashion, as a litigator does. I am no longer a litigator, and so I can say other things.
She's my Luther.
I'm Luther. I'm her anger management. Anger translator. So Janai, tell us a little bit about what it was like to get that question and how you approached confronting that question in light of, LDF was part of the litigation in SSFA. So we have been kind of on this journey with this court.
Yes. 86 years of a journey. So first, I must start by saying thank you so much, Sherrilyn, for including me in this really illustrious panel. I am delighted to be back at Howard University School of Law, back in the moot court room. The last time I was here, I was literally being mooted by the one and only Sherrilyn Ifill and some other incredible colleagues who took the time to help prepare me for the Louisiana versus Calais argument. So it is beautiful to return to this space. And thank you, Howard, for hosting me. And thank you to Dean Fairfax. This is just a wonderful gathering. I also see some former LDFers, Elaine Jones in the audience. Yes. Our Associate Director-Counsel, Todd Cox, in the back there. And Demetria McCain, our Director of Policy, and then a board member, Cecilia Marshall, who is Thurgood Marshall's granddaughter. So LDF is in the house and represented well. So let's dig into this. I just wanted to talk about this in the context of the broader landscape. It is not news to anyone that our democracy is under an all-out assault. If we just look at voter suppression alone, if we look at the geyser of gerrymandering that's happening across the country. If we just think about election denial and the big lie, the record amount of money in politics, each of those individually undermines the integrity of a democracy, but collectively, it is truly decimating democratic norms. And Louisiana versus Calais is situated in that. It's a symptom of this broader effort to destroy our democracy. And it's been a fairly long march on this path towards, what many are calling an electoral autocracy. That's really what we're facing if we don't grab a hold of this. Louisiana versus Calais is really a emblematic case of a typical Section 2 violation. It is nearly identical. Section 2 of the Voting Rights Act. Yes. It is nearly identical to a case that the Legal Defense Fund won just about 2 years before we had to re-argue similar facts in Louisiana versus Calais. That case was Allen versus Milligan. That was a case out of Alabama. And it was your staple, your sort of bread and butter Section 2 of the Voting Rights Act violation. Section 2 says that there cannot be a practice or procedure that denies or abridges the right to vote on account of race, and that includes gerrymandering. That includes the drawing of district lines in ways that dilute voting power. In the state of Alabama, for example, where Black people make up 27% of the population, and out of 7 congressional districts, we're only able to elect a candidate of choice in 1. We were able to prove that that was not just a result of happenstance, that was not just based on historical discrimination, but current discrimination, based on the way that the map was surgically drawn to pack Black people into a single district and then to spread the rest of the clusters of Black communities out across the remaining districts to dilute their power. The exact same thing happened in Louisiana. In Louisiana, the Black population is 33% of the state, even higher, the second highest of all states except for Mississippi. And again, if you look at Louisiana's congressional delegation, there are 6 districts. In only 1 could that 33% Black community elect a candidate of its choice. The math alone tells you something is amiss. But we know that Section 2 does not allow us to simply say, this is not proportional representation and then case closed. In fact, there was a compromise in the Voting Rights Act to make it so that proportional representation alone is not a right. You have to prove something else. We can talk about whether that's a fair negotiation or not. It just shows you how even in our most transformative pieces of civil rights legislation, there were compromises that would undermine the ability of racial minorities to truly get the electoral power that they deserve in their measure. But let's put that to one side. After you prove that not only is this disproportionate, but there's a history of discrimination, there may have been procedural departures and how the map was drawn, there are current racial appeals, there are various and sundry factors that support a finding of discrimination. You have to prove all of that and some threshold factors. Then you can still find your racial remedy being undermined by the very concept that Sherrilyn explained, this idea that we should be colorblind, the idea that using race to remedy racial discrimination is itself reverse discrimination. And I want to say a word about that term, reverse discrimination, right? Because that's really what pervades all of this. And it's something that we're hearing more frequently now. And yes, SFFA was very much the most recent reintroduction of that concept and this idea of colorblindness into the legal zeitgeist, and that has done so much destruction. But this really started back with Bakke in 1978, right? That was the first case where you had a person applying to medical school at UCLA challenge an affirmative action program to say that they were being discriminated against because of the small number of opportunities that were finally being afforded to Black applicants. And carry that forward to today, we're seeing SFFA being utilized in cases that are well beyond the scope of higher education, well beyond the scope of university admissions policies, which is what that decision was narrowly focused on. And we're now seeing that case and others cited in voting rights litigation. And so we are now waiting for a decision from this Supreme Court in a re-argument, which I need to really underscore is exceedingly rare that the Supreme Court would ask us to re-argue the case. We're waiting on a decision that has the potential to be as consequential as Shelby County versus Holder, which is the 2013 case that disabled Section 5 and effectively gutted the Voting Rights Act. It left us only with Section 2 as our tool. And we can talk a little bit more about the details of, Section 5 versus Section 2. But suffice it to say that the Supreme Court in 2013 effectively took away like half of the Voting Rights Act, if not more, by disabling Section 5. It left us with Section 2, and now we're awaiting an answer to the question that they presented in re-argument, which is whether the intentional creation of a district, a majority-minority district, we call it an opportunity district because they don't all have to be majority-minority. They simply need to afford voters who've been discriminated against an opportunity to elect a candidate of choice, whether an opportunity district violates the 14th and 15th Amendments. And our answer to that is a resounding no, for a few reasons that I'll say really quickly because I really do want to hear from our co-panelists. But first and foremost, the 14th and 15th Amendments foreshadowed the very things that we are experiencing now. They knew that by simply saying there's equal protection and that there's a right to vote free of racial discrimination, that was not going to just reset this country and that there would be no backlash and there would be no violent contestation of these new rights afforded to formerly enslaved Africans. That's why they included the penalties. That's why they said if you deny or abridge the right to vote, your congressional representation will be reduced. They knew it was coming, right? And so they put in there that clause that specified what the penalties should be. They were very careful in crafting that amendment to the Constitution to carve out certain groups of people. If you participated in a rebellion or a crime, they were very specific about who and what should happen if there was a violation of voting rights. And what we did for the next century was completely ignore those two amendments. Completely ignore them. I will even quote from Chief Justice Roberts, of all people, in the Allen versus Milligan decision, where he pointed out that for the century following the 15th Amendment, it was nothing but a parchment promise. Those were his poetic words that I had the delight of repeating back to him in the oral argument. That was probably the sweetest moment in the entire thing. But it was real because it is just a parchment promise without the animating legislation that is the Voting Rights Act of 1965. And one final point about how foreshadowed all of this was, in all of the Reconstruction amendments, 13th, 14th, and 15th, there's an invitation to Congress to use its authority to create legislation to enforce those provisions. There is an invitation to Congress, and Congress has failed time and again to take up that invitation in a robust way when when its enforcement powers are under attack. And so when we talk about the consequences of this case, and I'm happy to go back in Q&A to talk more, but when we talk about the consequences, it's not just the voting rights of the brave, extraordinary group of voters and advocacy institutions that we represent in Louisiana versus Calais. Their rights are being challenged. It's not just them. It's not just how the lines drawn in Louisiana infect and degrade our constitutional body as a whole, because we now have people elected on discriminatory lines representing all of us and creating national legislation based on racist lines. It's not just that. It's the fact that it's testing whether this Supreme Court is going to honor stare decisis, is going to honor its own precedent that is, the ink is probably still not dry on the Allen versus Milligan decision, and they're thinking about potentially rewriting it, an opinion written by the Chief Justice of this court. All of this is at play against this backdrop of unprecedented off-cycle redistricting that is coming at the direction of the White House, when we're seeing district lines manipulated across the country for sheer partisan gain and minority voters are being exploited in the process. All of this is the crucible in which we find this assault on our democracy. And so Louisiana versus Calais is, again, a symptom of that effort to destroy our democracy. Even though many people tell me on a daily basis that we are going to lose this case, I remain hopeful. I recall the similar, and I know Sherrilyn, you do too, similar prognostications when we were litigating Allen versus Milligan and we won. And when you do this work and you believe in the righteousness of your call and you know the law as written, you have to have faith that the Supreme Court will do the right thing while also planning for the worst. So when this decision drops, whatever it is, we are ready to get to work because the fight will not be over no matter what the decision says.
Ladies and gentlemen, ladies and gentlemen. Thank you so much, Janai. Thank you for arguing the case and being on the wall. This is so important. And it's funny you pointed out Elaine Jones, who I saw nodding vigorously, because Elaine was well aware and part of the conversation around those compromises to amended Section 2 of the Voting Rights Act. And so what's in this room is a long arc of folks who have been deep in this voting rights struggle for a very, very long time. So thank you for that, and thank you for the argument. I want to move now to the Congressman, and please, I hope you don't mind that I didn't start with you. I know you have a schedule and a vote and all that stuff. But I wanted to move to Jamie Raskin, who is not my congressman, but kind of is my congressman because and brilliant constitutional lawyer, and really in some ways the conscience of the House, but also the greatest legal mind in the House. And we count on him. We count on him to get it right and to draw the lines where they need to be drawn. But he also is a visionary. He's also a creative. He also is a scholar. And I was wondering if you could just kind of give us the landscape. I know we want to talk about the SAVE Act a bit, and whether or not something is going to happen with that. But tell us what is going on. Are you all still on vacation? How long is Easter vacation? Easter was like 2 weeks ago. Like, are you still like doing Passover? Like, what is happening? Because we've all been working. We've all been working.
Well, Professor Ifill, first let me thank you for inviting me to be part of the conversation today. And I was very moved to watch the parade of students come up and to sing your praises. And I think I might speak for everybody in the room in saying I'm your student too. And I thank you for always being there for me. I don't know if we speak on a daily basis, but certainly a weekly basis. We're always talking and brainstorming and strategizing. And I just love the way that Sherrilyn Ifill's mind works. It is alive to history, and it's alive to possibility for the present and the future. So you are indeed a great teacher. Yeah, well, I don't know if we're on vacation exactly, but there's a vacancy in Congress. Now, we tried to get them to come back during the most recent crisis where the president was threatening war crimes and potentially genocide, but we were not called back. And yet We are.
And you have to be called back by the speaker in order to come back.
The speaker's got to call us back. Yeah.
You all have keys. Can you get in?
So we can get into our office, but we can't get into the chamber. But anyway, we will be back next week, and there's going to be a lot of action around war powers and the War Powers Act and War Powers Resolution, and a lot of conversation about the 25th Amendment, about impeachment, about what constitutional vehicles are there to deal with the current crisis. But I would say what we're here to talk about today is the background for all of that, because it's a profound reaction against the civil rights movement and the second Reconstruction that we're living through here. And one way to think about it is that every component of the 14th Amendment is under attack today, beginning with the very first sentence, which says that all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States. And so this was argued recently. Of course, they're advancing such outlandish, outrageous arguments that even their gerrymandered, stacked and packed Supreme Court has got to regard with skepticism the propositions that they're advancing. But that is very clearly under attack, as is due process, which has been under attack since day one of this administration, with the expedited removals of people in the immigration process and lots of other attacks on basic due process with immigrant rights. You know, one of my, we were talking about due process on the floor. One of my colleagues said to me, well, you don't support due process for guilty people, do you? I said, you know, that's the whole point, okay? We don't know that they're guilty until there's been due process. And due process are probably the two most beautiful words in the Constitution. Maybe the two most beautiful side-by-side words in the English language. Equal protection is beautiful too.
Birthright citizenship.
And equal protection is equally under attack in this period. As we all know, the 14th Amendment Equal Protection Clause works a lot better for white men than it does for anybody else in the country, including the people that the Supreme Court had repeatedly before identified as the deliberate beneficiaries and object of the Equal Protection Clause. So they've completely flipped it over on its head. But it's not just Section 1. Section 2, I very much appreciated the presentation of your students, Sherrilyn, about Section 2, and I'm hoping we'll have some stuff to talk about. As you know, it's never been activated in that way. That is, there's not been a legislative reduction of the apportionment basis for population in states based on disenfranchisement, racial disenfranchisement or any other kind. But if we are living through another period of profound attacks on people's voting rights, whether we're talking about closure of polling places, we're talking about throwing people off of the rolls, you know, you name it, then I think we're going to have to look at that. And it raises very complicated problems that I would love to get into with your students when we get to that point. And of course, there's also the question of, if you lower the population basis for a state that's disenfranchising, how do you know you don't end up hurting the people who we want to be helping?
We're coming Tuesday, and we've got all those questions lined up, like the issues we would have to get through, but we're coming Tuesday.
On Tuesday?
On Tuesday, yeah.
I love it. Okay. You know, Section 3 of the 14th Amendment, we saw gutted by the Supreme Court when Colorado tried to actually implement it. Section 3 says that anybody who has sworn an oath to support the Constitution of the United States and then violates that oath by engaging in insurrection or rebellion against the United States shall never be allowed to hold public office again. And Colorado, exercising its powers over ballot access, denied Donald Trump the right to be on the ballot based on Section 3 of the 14th Amendment, and that was overturned by the Supreme Court. So, you know, we can take it through Section 4 of the 14th Amendment, which I was thinking about actually this week, because you'll notice that the Trump administration has been writing checks to a lot of their friends, including Michael Flynn, the disgraced former national security advisor who pled guilty twice under oath to having committed perjury about his contacts with Russian officials. And then he brought a lawsuit later to try to, withdraw what he had said in his guilty pleas and to sue the government for a false prosecution. That was thrown out by a federal court, and nonetheless, the Department of Justice just gave him $1.5 million to settle a case that he'd already lost in federal court. And now we've got insurrectionists, Proud Boys, and Oath Keepers all filing millions of dollars in lawsuits against the federal government, like President Trump has himself filed a $10 billion lawsuit against the IRS and a $320 million lawsuit because of the perfectly valid search warrant that was executed at Mar-a-Lago. The Section 4 of the 14th Amendment says that the people shall not have to pay any debts undertaken or incurred in the course of insurrection. And if that applies to the 1860s, it should apply also to the 2020s in America too. We should not be shelling out $1 for any of the people who committed insurrection against the country. So in any event, every part of the 14th Amendment.
And Section 5, which puts the power in Congress's hand, and we are seeing that power usurped. Look at what's happening with the Department of Justice. I mean, it's essentially taking over what should be congressional power.
Absolutely, and that's what Shelby County versus Holder was about. Shelby County versus Holder dismantled effectively Section 5, as Janai explained, by finding that the coverage formula was obsolete or antiquated, and therefore failed the new proportionality congruence test under Section 5, essentially putting congressional powers in a straitjacket in terms of what Congress can do. But look, I now here, I'm not going to compromise anybody's 501c3 status or anything, because you guys are an academic institution, you're nonpartisan, I'm not nonpartisan. I will say, I certainly intend for Congress to change hands in November, and I hope to be wielding a gavel when we get back in January of next year, and I hope to be turning it around on every front. But let me just add to a couple of things that Janai said in her excellent presentation there, and to something that you said, Professor Ifill, because you invoked Justice Harlan's creation of the colorblindness metaphor in the concept. And of course, in the context in which he used it, he was opposing the majority's decision in Plessy versus Ferguson, which was to authorize Jim Crow, to authorize de jure segregation, apartheid in America. And so he invoked the idea of colorblindness to try to attack the very long history of racialized injustice in interpretation of the Constitution. But even in the course of doing that, you quoted that paragraph that came right after the colorblindness metaphor. I want to talk about the paragraph that came right before, where he said that the white race, and I'm not sure I'm going to get it exactly verbatim, but the white race deems itself dominant and superior in matters of prestige, achievement, education, wealth, and power. And he says, and so I have no doubt it will always be. But in the eyes of the law, the Constitution is colorblind. So the juridical concept of colorblindness was born with a de facto statement of permanent white supremacy in the country, which demonstrates that it was the radical Republicans who had the right idea, which is Section 5 of the 14th Amendment. You've got to use the government as an active instrument for promoting equality and justice after centuries of apartheid and discrimination and racism and white supremacy in the country.
And we must not forget that Justice Harlan also was the dissenter in Wan Kim Ark.
Yes, indeed. But so I wanted to make one other point, prompted by something that Janai said. the whole very slippery doctrine of colorblindness is now being used to try to destroy the 14th Amendment in every part. And the way it's working in voting rights, I think, turns on a Supreme Court decision called Shaw versus Reno, written by Justice O'Connor, a 5-4 decision. But to me, one of the most remarkable and pernicious decisions ever written at the Supreme Court level in the country. What it found was that although there's no constitutional right to have a square district or a rectangular district or a neat-looking geometric district, and although it's not unconstitutional to have a majority white district, no, that's the constitutional norm, that's the baseline. If a state draws a district which is not neat-looking, which is, quote, bizarre-looking, and there's a majority of African Americans or Hispanics in it, even if it follows the principle of one person, one vote, it's got the exact same number of citizens within it as it's got voters in it as the neighboring district, it's unconstitutional, or it's presumed to be unconstitutional. And so this institutionalizes a racial double standard. Essentially, everybody, or at least white people, have a right not to live in a so-called bizarrely drawn majority black or Hispanic legislative district. Nobody's got a right not to live in a bizarrely drawn majority white district. That's the norm. You know, sometimes they talk about bizarrely drawn districts in Maryland. Our state is bizarrely drawn. You're not going to get squares and triangles out of it. Nobody thinks that's a serious constitutional idea, including Justice O'Connor and the people who drew it. But they introduced this idea, and now I fear that the people who want you to lose in the Calais decision are interjecting and infusing the Shaw versus Reno consciousness into the field of Voting Rights Act remedies. So that if a state says, well, we want to make sure that everybody's got a fair shot to be electing people of their choice, we're going to create, as they did in Louisiana, a second majority African-American district, which doesn't even get the African-American population up to the point of proportionality, but we think that this is a fair thing to do. No, that is deliberate race consciousness and a violation of the colorblindness principle, and the district doesn't look like a rectangle or a square to us, kind of thing. So, but we've got a very serious problem with what's taking place on the Supreme Court, and it is steadily dismantling all of the gains that were made during the civil rights struggles of the 20th century. And let me just close with a thought on that. Some of these things we can and we should be able to rebuild the statutory architecture of. We are fighting, and we've been fighting for the John Lewis Voting Rights Act to try to repair the damage of Shelby County versus Holder, essentially saying, all right, you think that the coverage formula is out of date. Let's do a screen of discrimination over the last 25 years in the states, and that could be the basis for it. So we're trying to jump through all of the hoops that the Roberts Court has created. We don't think that that's a panacea, because this court can squint very hard and find a problem with anything that advances the rights of the people. And so fundamentally, we believe it is a time for us to be talking about even more sweeping changes of a political and constitutional nature. You know, Tocqueville said when he wrote Democracy in America that voting rights and democracy were either shrinking and shriveling away, or they were growing and expanding. We've been in this terrible contractionary mode over the last several decades. We've got to get back on the democracy growth track. Yeah. One way of doing that, this is not, you know, and I want to tell you law students here, this is not all done in court. A lot of it is done in the states. It's done in Congress. It's done in the streets. And one thing I agree with President Trump about is statehood. Not for Canada, not for Greenland, not for Panama, but how about starting with Washington, D.C.? the only federal capital on planet Earth where the people are disenfranchised. And you know, it's not pie in the sky. The House of Representatives, we've passed it twice. I got to be the floor leader on it the last time that we did it. When I got up, I said I wanted to thank 713,000 tax-paying, draftable U.S. citizens who have a bona fide, legitimate political grievance against Congress, and yet did not come down and beat the daylights out of our police officers and put them in the hospital and shut down the Congress of the United States. They've done it the right way. They had a statehood constitutional convention, and we've got 3.5 million Americans who are completely disenfranchised in Puerto Rico. How about statehood for Puerto Rico? And how about some universal constitutional changes that we need? When the Constitution was written, there was no constitutional right to vote because a majority of the people were disenfranchised. The enslaved people were disenfranchised. Women were almost universally disenfranchised. People without property couldn't vote. People without wealth couldn't vote. How about it's time in the 21st century for us to pass a constitutional amendment guaranteeing the right for everybody to vote, so we're not constantly playing catch up with all of the voter suppression mechanisms. So there are a bunch of reforms like that that I think will kind of thrust us forward in terms of democracy reform at the same time that we try to reconstruct the things that have been so carefully gutted by the Roberts Court. Thank you.
Thank you. Thank you. They must be so upset when they see you coming. When you. Unbelievable. Can you say a quick word about the SAVE Act? Should we not worry about it?
So no, I call it the Save MAGA Act because it has a very deliberate purpose of trying to disenfranchise millions of people. The problem it's supposedly addressing is illegal aliens voting, and you've got a much greater chance of getting hit by lightning in a building than you have living in a place where an illegal alien has made the stupid
undocumented person.
An undocumented person. I'm sorry, I've adopted their language there. But look, the SAVE Act, as it first came to us, here's what they said. Oh, well, this is just a voter ID law. Okay, no, that just gets you in the door. You start with your driver's license, right? But that doesn't prove you're a citizen. They want you to prove you're a citizen. So where's your birth certificate? I assume everybody in the hall here knows where their birth certificate is, right? So you got to go find your birth certificate. Let's say you can find your birth certificate. Well, we want to make sure that the names match to prove you were born in the United States, right? Well, half of American women who get married have changed their names. So, or more than half, I think it's like 70 million American women, right? So your birth certificate now no longer proves that you're a citizen. All right, well, that's no problem. Just bring us your passport. Well, half of Americans don't have a passport. Oh, well, that's all right. We're going to impose an unfunded mandate on the states to create a special voter identification that you can go and get for 50 or 60 bucks. Well, that's a poll tax, right? So all of this for nothing other than to drive people out of the voting range. And the Republicans passed it unanimously in the House. It's gone over to the Senate. I believe that the Democrats in the Senate are uniformly opposed to it, as we were overwhelmingly, and so that they will stop it. But President Trump has been insisting that nothing pass unless the SAVE Act is appended to it. And some of them are talking about actually going nuclear, that is, exercising a 51 vote option to abolish the filibuster in order to pass the SAVE Act. So no, we're not out of the woods yet on this one, but I believe that the president's numbers are sinking like a stone, and his coalition is fracturing, and I just hope that they don't have remotely enough political support in the country to accomplish something so radical as this, which really could, if it's passed, violate the 19th Amendment, because so many women will be driven out of the ability to vote and the right to vote.
No, thank you for that. I don't want us to forget that, so keep the heat on, keep the pressure on, really important. Professor Codrington, I'm so glad that you're with us today, and you've had a chance to hear the presentations of your co-panelists, but you yourself have done a lot of writing about the move of the Supreme Court in this space, with the Purcell doctrine and all these other ways in which, what we're confronting is just such a web of interactive activities designed to try and roll back voting rights. And I wondered if you could just kind of pull some of that together for us and weave in the Supreme Court into this conversation as well, beyond the Louisiana versus Calais, where they're at least being upfront about what they're doing. There are other ways in which the court, by more nefarious and procedural means, is able to accomplish the same thing. So share with us.
Well, thank you. Thank you for having me at this great university with these distinguished panelists. You have so many titles. I have just one, it's professor, but I'm gonna call you all professor because you're all con law professors as well. So thanks for this distinguished academic panel that has such practical repercussions. And so, yeah, this is a web. It is just, it's worse than a web, it's a miasma. It seems to be intentionally designed to suppress and disenfranchise and disempower the most vulnerable communities. And that often includes communities of color, Black folks like us sitting here. And so I'll talk a little about the Purcell principle, which ironically is tied to Louisiana versus Calais and Allen versus Milligan. But, Purcell, when I started in the academy, Purcell principle was kind of just picking up. It was articulated in 2006. It was an Arizona case, Purcell versus Gonzalez. And basically, the idea that the court announced there was that in the lead up to elections, that courts should not intervene. They should not intervene in cases to change the law on a preliminary basis or otherwise that might result in confusion. People get confused close to elections, and so theoretically you can understand that. Mind you, this was a case about a voter ID law in Arizona. At the time, one of the most restrictive voter ID laws in the country. Now it seems kind of quaint, sadly, but that's what was going on. So we had this idea, this principle, this theory, Purcell, don't change rules in the lead up to elections courts. That sounds great. The problem is Purcell is under-theorized and it's flabby. And so you just say something like that and it does not answer so many questions. Courts do not step in before elections. Well, is that a federal court or is that a state court? We later come to find out through the reading tea leaves that it's probably federal courts most of the time. That's where we're gonna stick. How long is the lead up to an election? That gets progressively longer depending on what the case is. Maybe up to a year if we look at Allen versus Milligan. What do we do if the law is flagrantly unlawful or unconstitutional? Don't know yet. Although we've seen some cases where we've learned they were flagrantly unlawful, like Calais and Allen versus Milligan, and yet the court stopped those on the interim basis. And so all of these questions and so many others emanate from this Purcell principle, which just seems to be now used in a way that benefits Republicans, just straight out at this point. If you look at the scoreboard, it is just like Purcell is on the side of Republicans, and so there's no hiding this at some point. And so one of the problems is we already have standards to think about whether or not we're going to intervene in an election. They're called stays and injunction standards, equitable remedies. And so Purcell is now, at this time, it seems to be cannibalizing all the sort of standards that we used to have in this way that is very motivated. But so I said this is all related to Calais and Allen versus Milligan because, I mean, in the ways that I just mentioned, but also because Purcell was used in this innovative way to apply to those. And so the interesting thing about Calais and Allen are those are redistricting cases. And if Purcell is really about confusion, we don't want to confuse voters. Later they said, we don't even want to confuse election administrators. I'll give you that. We're extending it and extending this principle, but like sort of quietly. in the redistricting cases, after a census, we don't have maps anymore. Now, when we have a census, we're counting up everybody in the country. We're trying to figure out who fits in what districts, first and foremost, for the one person, one vote principle, right? Every district has to have equal numbers of people. And so before the census, that would have changed. People would have moved. They would have died, they would have relocated, all that stuff. And so we have to do that first. And so Purcell should not really apply then, because there's no confusion if you don't have a district, right? We're starting on a blank slate. So if a law goes into place and that law is said to be unlawful, violating this statute, this redistricting statute, but there are no districts, it's not clear how anyone is confused. And so that itself was problematic. But it's more problematic because when the Supreme Court stayed that decision, and this is over the vote of John Roberts, who is not a friend of the Voting Rights Act, he said that it seemed to me that Section 2 was applied according to law. There's nothing to question here. He was on the losing side for that stay opinion. And that, to me, was one of the wildest things, but the wilder thing of it all is after they decided Milligan on the merits, then you get another election with a proper district, and instead of the white Republican who was in place, you get replaced by a black Democrat. Now that happened in Louisiana with Calais as well, the predecessor to Calais, Georgia, and all of this applies because Section 2 applies nationwide into all elections. This applies the whole way down, state elections, local elections, what have you. And so we could have had 2 black Democrats at least in office in the 2022 midterm, and we didn't because of the Purcell principle. So that's problematic. This is all happening on the shadow docket, which I will note was named by Will Bode, a conservative scholar, popularized by Steve Vladeck, a liberal scholar, and hated by the Supreme Court because it gives the whole game away. It gives the game away that the way that they are using this docket is to operate and make law in the shadows. Typically, when the Supreme Court gets a question, it goes through this whole process, and then you get to the merits decision. That is going to give us a case that we know has precedential value. It is going to bind all the parties to that particular case and what have you. The shadow docket or the emergency order docket, that docket is supposed to be for interim relief. Whenever the Trump administration loses, the case somehow gets on the emergency order docket. Like everything he loses is an emergency. And that just can't be the case. I mean, we are facing a lot of emergencies, but it's not every time that he loses. And so we have the shadow docket that's happening. The problem with the shadow docket is you don't brief the questions, you don't argue the questions. The Supreme Court doesn't rationalize its answers. Often there's nothing that comes with it except for this is the decision. And worse than that, lower courts don't know what to do with this. We don't know the value that it has, precedential value. And the Supreme Court seems to like arguing with journalists and lower courts through its own means to make them look like they're doing something wrong by not following what's going on, but they're giving no guidance here. And so that's deeply problematic. You take that combination, the Purcell and the shadow docket. Mind you, Purcell is occurring on the shadow docket. That's why we don't really know anything about it until we do. We have a dangerous situation here, a situation that screams the need for reform. And so at least the way that I see it in those 2 ways, we have a real problem that seems connected to everything else that has been discussed on this stage.
Now you messed me up. I was feeling a little bit, Janai had got me going, and then the congressman said we're going to do it, and then Will said, no, you're not. No, that's great. It's so important for us to understand because this is such a priority when we get to the other side. If there is an opportunity for transformation, for change, for re-envisioning and reimagining, it is not just about changing the outcome of one particular election or another. We have a structural problem from STEM to whatever the other part is. STEM to, what is it? STEM to Stern. Oh, STEM to Stern, yeah. We have a problem from STEM to Stern that has to be changed and transformed. We didn't get here because the systems were all working, you know? We got here because the systems were vulnerable to being taken advantage of by people without ethics and who don't believe in the principles of democracy. So our job is not only to deal with how do we navigate this moment and regain some measure of power, but it's also being really rigorous about looking at the structural, like this idea of the Purcell doctrine, a shadow docket case, kind of eating alive, you know, even for litigators, deciding whether, can I file this case now? How many times have I heard, oh no, Purcell is gonna, right? So people are even stopping themselves from litigating because of this flabby, would you call it flabby and under-theorized, I really like that, under-theorized doctrine. So we have a lot of deep work to do, and because you've laid it out like that, now I feel compelled to throw on top of it something deeply problematic as well that I don't think is addressed by any of the traditional solutions that we have talked about in terms of the John Lewis Voting Rights Act, in terms of the democracy, what was the package called? The democracy something, the bills that would, the two, you know what I mean. You don't have to tell me the name of it. But we had a whole series of democracy measures that were supposed to get at some of this. And I'm just seeing this happen more and more. It just happened in Louisiana this week. That when someone is elected, and again, I am not speaking from a particularly partisan lens, but this is how it has been occurring. When a Democrat is elected, that would change over a district, that the lame duck session of the legislature uses the time between the election and the time the new person takes office to remove the power of that office. We saw it when, was it Roy Cooper was elected in North Carolina as governor. We saw it happen to Andy Beshear as governor in Kentucky. We've seen it happen in Wisconsin. We just saw it with this black man who was just elected as a clerk of the court in Louisiana, where they decided to eliminate the position. We're seeing it happen with prosecutors where powers are being removed from them over certain kinds of cases, what we would call these third-generation cases. And I've been writing about, this is a chapter in my book, and I'm not seeing where any of the legislative fixes or other even Supreme Court kind of reform fixes that we have talked about addresses what I see as this power, this problem. And the reason this problem really is so deeply problematic is because it suggests that voting doesn't matter. That even if you win the election, the power of the person that you elected is going to be taken from them by that lame duck. So to the extent we're always counting on this transformative election thing to happen, this seems to me really dangerous, and I just don't hear people talking about how we confront this reality, that is what's happening right now, and that will be happening, let's say this fall, right? There's an election, a midterm election, that between that November midterm election and January, when the new people are sworn in, all kinds of things are gonna happen, right? And that's gonna be at the state level as well as at the federal level. So I just was hoping that any of you could address your thoughts about, and I'll put it in the book, but I'll attribute it to you. I'll attribute it to you. But I do think this is a very deep and profound problem that speaks straight into whether we will be a democracy or not.
But look, welcome to my world. I mean, we have the constitutional power to declare war. And Donald Trump just went completely around that and started a war without us. We tried to raise this through the War Powers Act, and
but your official power wasn't taken. You have someone who's usurping your power, which is different than recalibrating the actual legal powers of your office.
No, I agree,
right?
but that's just the extreme version of what we're all living through right now. Now, I do believe, and Janai will undoubtedly have the sites at hand, but I do believe there were some cases back when the Voting Rights Act had more strength and muscle in it, where there were cases like that where the mayors were abolished, county commissions were abolished.
And the Supreme Court said in Presley versus Etowah County that those things do not violate the Voting Rights Act and that the Voting Rights Act doesn't cover those things.
That was not always the position, though, right?
This case was 1992 was Presley versus
Okay,
Edward
yeah,
County.
but I guess,
We used to think-
maybe I'm dreaming it, but like
We used
back
to
in the
think it was.
70s and the 80s.
We used to think it was,
Yeah.
indeed. And then it
Yeah.
made its way up to the Supreme Court.
So,
and the Supreme
okay,
Court said-
then here's my answer to you. You're absolutely right about that. And this is why I'm glad that your students are here at this great law school and in your class, because, what we're here to fight for is not just the enforcement of the law, but for justice. And that means you often have to take on a Supreme Court, which is plucking doctrines out of thin air in order to thwart movements that were designed to vindicate justice and equal rights for everybody. So, and there's no guarantees in this business, as you know. You want to guarantee, you buy a dishwasher. You want a democracy, you go out and fight for it every single day. So.
Janae, you want to add something on that?
Because this is not new at all to the work that we've been doing at the Legal Defense Fund. Many of you may have heard the story of the Mayor Braxton in New Bern, Alabama, who was elected duly after there had been no elections in that predominantly black municipality. He was elected, and then they stole the keys. Like, they literally physically locked him out of power. Right? So there's the changing of the rules, there's the locking of the doors, there's moving the goalpost, there's changing the rules of the game, because there is no magic formula that they're going to say, okay, that's legitimate, yes, uncle, here's the white flag, we surrender. We will always be fighting for power in this country. We will always be faced with either violent opposition or this manipulated opposition, even from some of the institutions in this country. So there's no magic bullet for it, but it is true that in some of the legislation that we're putting forward, we have the opportunity, especially at the state level. One of the things I thought you were going to mention about Louisiana was that we introduced a Voting Rights Act in the state of Louisiana this week. People are saying that one will never get passed in the South, right? But you have to start somewhere. You do not get a Voting Rights Act passed in Louisiana, Mississippi, Alabama without introducing one, right? So we are not going to not do it. We are going to build the coalitions, get the right people to have an opportunity to compete in elections so that we can get a Voting Rights Act passed that addresses some of these structural concerns. And we have more and more that are being passed across the country due to the work of so many of our team members here and our colleagues. And that is going to be one of the next frontiers as we build toward the next 250.
Ladies and gentlemen, please give a round of applause to this amazing panel. Thank you so much. Keep your ears open. Pay attention to what is happening. Pay attention to the SAVE Act. Go to the Legal Defense Fund website to find out what's happening in the cases that are in the Supreme Court. Go to the 14th Amendment website. Follow the extraordinary work of Professor Codrington. And we are about to move right into our next panel, so do not go anywhere. But first, one more round of applause for these folks.